having said this, I wanted you to see one. This particular thing, why I'm saying.
Yeah, Arun ko bhejna hai.
I think you can mute.
Sorry.
Okay. So in this, if you see, Honorable NCLAT has observed. So I think this is there or not. I will say this. I want to show you the order, but the problem is for everything time is taken more. That's the problem. So in this, this is different case. No, not this one. I think some other matter has come, not this. No, one. This is not opening in Indian Kanun. This only I wanted. Review security and all is asking. See? This, oh my God, again here they put, okay, anyway, I'll share the judgment little later because I wanted to download and see the judgment. I have not seen it at all. But what in this particular matter, the Honorable NCLAT has upheld is that these provisions are directive. That only I wanted to show you, but unfortunately it's not opening. That page is not opening. So here, that was concluded by Honorable NCLAT in this particular matter, that 35A is directory. But I wanted to say on what background they said directory. That's why I wanted to show. Anyway, fine. I will, because we have left with this time. I don't want to too much waste my time. Wait, I'll see in this whether I can get. See, in this, now you can able to see the timeline prescribed in regulation 35A or CRP regulation is only directory, and any action taken by RP beyond timeline prescribed under 35 or CRP cannot be held to be non-est or void only on the ground that it is beyond the period prescribed under 35. That means what they are trying to say, it is mandatory on part of the RP under regulation 35A that you have to stick on the time, but just because of it is mandatory that it has to be done in 75th day, 115th day, and 130th day, that doesn't mean if something is filed after that is not valid or void. The Honorable NCLAT said in this matter, Aditya Kumar and Om Prakash Pandey, they said just because of timeline is mandatory. But they never said that it is not mandatory to follow timeline by RP. They say what the court has observed, order has been passed is that even the RP files beyond this date, it cannot be invalidated just on the ground that timeline is breached. Just because of timeline is breached in filing avoidance transaction does not invalidate or does not become void. So the matter can be proceeded further. That means it is mandatory, but that it is not that just because of the IP is skipped from doing that within this timeline will will take away the right of RP from doing it. Subsequently also you can do, but this is a mandatory. Probably the question may come if the IP does not follow this timeline. Okay, the question may come from regulatory authority, why it's not complied with. But the honorable inclined in that particular cases is just because of timeline is not filed within the time does not mean the matter should not be proceeded further. That means after that also it can be filed. Okay. So now, but it is mandatory on part of the IRP that he shall form opinion within 75 days on or before 75 days. Same way, he shall make determination on or before 150 date, and he shall apply to AA on 130th day. Okay. The resolution proposal shall submit to the committee of to the committee all plan which comply with the requirement of the code regulation made thereunder along with the details of following transfer. So this is very important that with these details only he has to submit to the committee the resolution plan. What are the avoidance transactions are there? So these are the sections which I would like to deliberate in detail. Section 43 preferential transaction and 44 order in case of 45 avoidance of undervalued transaction, 46 relevant period and 47, and one by one I will take you through one by one. Okay, what is the meaning of preferential? Let's understand the meaning of preferential. What is that? Preferential means. What is that preferential? Any idea? Advantages, special,
preferred.
Yeah, that's why I put everything here.
Yes.
Okay. All are closer to that. Okay.
Yes.
These are, if this kind of a meaning comes or this kind of a interpretation comes, then we can, because there is no definition for preferential. So we have to see that somewhere we are picking out. Okay. Now, just an illustration. Okay. And before that, what I will do, I think time frame before taking you through. Yeah, this is important before going to that. Where liquidator or RP as a is of opinion that, okay, I'm reading 43, okay, opinion that the corporate debtor has at the relevant time given a preference in such a transaction in a manner as laid down to any person. Here, very important is that any person as referred to in subsection 4, he shall apply to AA for avoidance of preferential transaction and one or more orders of 44. Now coming to next, what are the ingredients of preferential transaction? A corporate debtor shall be deemed to have given a preference if there are transfer of property or interest. So mean to say property. If money is transferred, is it coming here or not? Covered or not? If money is transferred. Any idea? Transfer of property, it says, if money is transferred.
That also comes. Money is also part of property.
Correct, na? It's part of property, right?
Yeah.
We can just check it once. Must be part of the. Yes, it is a part of property. I just want to show you.
Definition.
See. Okay.
Property includes money, goods, actionable claims, land and every description of property.
Okay, so because the moment property, our mind goes into Transfer of Property Act and this, that, and everywhere. So let's not leave our mind to fly to those laws. Let's restrict to IBC itself. What it talks about property includes. That means it is not a exclusive definition, it's inclusive. Okay, it doesn't say property means. It is inclusive. It includes money. That means something else also can be brought in, provided the court is convinced with that. Okay. Property includes money, goods, land, and every description of the property. Coming back to this. Corporate data for the benefit of creditor or surety or guarantor for or on account of antecedent financial debt or operating debt or other liability. So here that element present, it should also be seen. Transfer of property or an interest of corporate data for the benefit of a creditor or a surety or a guarantor for or on account of antecedent financial debt or not. And here and should be understood as or only. Okay. The transfer in the class A has the effect putting such a creditor, okay, or guarantor in a beneficial position. So there should be a transfer. Then you should put the creditor in a beneficial position. Then it would have been in the event of distribution of asset. So this is very important thing that we need to see. These are the important elements that one should, important element that should be present to qualify under for filing an application under 43. So how to see this? Suppose how to make it? Suppose some PDC is given to one particular creditor, leaving other creditors. Is it a preferential or not? Some PDC check is given to secure the payment to X, and there is a Y also there, creditor is there, but PD is not given to Y. It is only given to X. But both are creditor at the same time. It's a preferential. It's a preferential transaction because it is antecedent financial debt. For that, you are giving a PDC within the look back period. That's more important. Okay. And what else we can say? Suppose that is a due of 5 crores to X. There's a due of 1 crore to Y. The corporate data, the credit, the promoter directors, they are settling the dues of X by paying 5 crores, keeping dues of Y 1 crore pending. Is it preferential transaction or not?
It depends on what type of creditor it is. If it is essential for running the business.
They are in the same terms and conditions. They are in the same footing. You are giving preference to somebody. You are giving preference to someone.
The management will pay to the creditor on whose his business is dependent.
No. See, if everything goes by management, this thing, then why court should be there? Why court should be there? Court and code is not required. Everything goes by logic. Okay. Here the question is that leaving lesser amount pending, what is the idea, purpose for settling the higher amount? This the promoter or director has a duty to satisfy the court.
Hey, suppose, sir, one doubt.
Yeah,
Suppose if he is on a regular course of business, he is paying the installments on time to a particular banker and not paying to the other creditor, for example.
Let it be.
What I'm saying is that, sir. So, as long as he is within the terms of the sanction of that loan, I think it is not a preferential.
Correct. It is not, as long as it is normal course of business. In fact, there is a Supreme Court judgment which I wanted to show you also. In fact, I am good that you reminded me. I thought
for example, suppose if he is paying them a loan, prepaying the loan, keeping the other loans pending, then it is a preferential. Yeah.
That's what I'm saying. See, idea is that, see, you can't say I should not doubt. That is my point, right? I'm a liquidator. You are a management guy. You can't say I should not doubt that. No, I have a reason behind it. All that. Let me also satisfy. Let me form opinion. Let me determine. Right? That's the duty of the liquidator. You have
Similarly, if the PDCs are given, mentioning the dates of the installments, such encashment of PDCs will not amount to preferential. Suppose if they are given a blank PDCs without date, and that the banker is using that as a recovery of the arrears, keeping the other loans of the other bankers pending, then it will be a preferential.
So this is a case law which I was telling you. The Supreme Court has the question before. There was a question before in the matter of. I'll show you here. Okay, in the Anuj Jain RIRP, JP Infra versus Axis Bank. In this matter, it is went up to the Supreme Court. Okay, indeed, there was two major disputes. One as to whether the transaction question deserved to be avoided as being preferential undervalued. Second, as to whether respondent could be recognized as a financial creditor and the strength of the mortgage created as collateral security.
Mortgage to the holding company.
Okay, correct. So here, if you see in that, it has been, I think, the conclusion.
That is, they're not ordinary course of business. Giving mortgages is not there. Ordinary
Okay.
course.
Yes, that was the conclusion given by the Supreme Court. The appeal preferred before NCLAT against the order dated 16/5/2018 as passed by NCLT and application made are dismissed. Consequently, order dated 16/5 so passed by NCLT appeal to the finding that the transaction question are preferential within the meaning which is the market created within the look back period. That was the finding. That was the order passed by Honorable Supreme Court. The appeal preferred before Honorable NCLAT against the order passed by NCLT. Application filed by lender bankers are dismissed. And respective order is restored, making that mortgage is a preferential transaction within the meaning of section 43. That was very, in fact, detailed case law we need to read. Then only we understand, we'll appreciate what exactly the Supreme Court dealt with the entire matter. Very important matter. Okay. I'll share this case, this thing, or then this particular document, and also you can also see in the website also by searching this very detailed judgment rendered on section 43 and what should be against. See, if the transfer exam is with reference to ordinary course of business financial affairs alone, they conveniently get excluded. So it should not be only on that ground. So even if not standing within the scope of ordinary course of business, such had never been a scheme of code or intent, it has rightly been contended on behalf of the appellant that for the purpose of exception, but where the internal usage record to be kept in view. If the ordinary course of business financial affairs transferee would itself decisive for exclusion, almost every transfer made to the transferee like lender bank would be taken on the note, which would practically result in frustrating. That means that alone should not be seen. That's the observation made by the Honorable Supreme Court. Here that mortgage has been brought within the purview of the section 43. Good thing you reminded, I thought, okay, I can show this. I was keeping this for this section only, that judgment. Okay, now going to next one. For the purpose of subsection 2, a preference shall not include the following transfers. What are those? A transfer made in ordinary course of business or financial affairs of the corporate debtor. Any transfer creating security interest in the property. This was deliberated. I was told also. Such security interest secures new value. What is that new value? What is that new value? New value is nothing but a new loan is taken, new sanction is taken, new facility is taken, and new machine is bought. And that machine is given as a security to that a new loan. So everything is new value. There's nothing to do with the antecedent. That's right. This is accepted. This is coming as an exemption to a transaction falling under section 43. New value is exempted. Provided that any transfer made in pursuance of the order of the court shall not preclude such transfer deemed to be giving preference. Okay. Now, with this only I was explaining. New value means a money or its worth in goods or services or new credit or released by the transferee of the property previously transferred to such is neither void nor voidable by the liquidator or RP, including the proceeds of such property, does not include financial debt substituted for existing financial debt. Should not be substituted for existing one. New, then it is exempted from the purview of the section 43. So a preference shall be deemed to have been given at the relevant point if it is given to the related party during the period of 2 years preceding the insolvency date, or preference is given to a person other than related party during the period of 1 year preceding the insolvency date. Now coming to the orders in case of section 43. What are the orders may be passed on application made by RP or liquidator?
Sir, just 1 minute, sir.
Yeah.
You go to that 43 subsection 3. There is a provision that any transfer made in pursuance of the order of a court shall not preclude such transfer to be deemed as giving preference. That means if you execute a court order, that will also be not precluded from considering that as a preferential transaction. That
Yeah.
means we should not execute the court order also during this look back period.
That period, yes. Because that means you are trying to see, the idea is that if you do that, you get benefited and you are breaking the 53 water flow. The idea is that you have to, once you come within the purview of IBC, IBC is nothing but from the date of
43,
CRP
sir.
commencement.
43.
No, that's what. IBC is not from date of CRP commencement. IBC is for the purpose of avoidance transaction is and going back 2 years in case of relative and going back 1 year in case of non-relative. So we have to understand that. Sorry, yeah. Okay. So that is the point they are conveying here. By executing order, it should not happen. This only you are telling, right?
Yeah. Suppose the court gives an execution or executing order and it happens during the look back period,
Yeah.
that will also amount to preferential transaction.
Yes. Yeah,
But
because
it is not a contempt of court.
Yeah. See, a code, it is a code. 238 to supersede everything. Okay. You should not ask this question at all. We have section 238 for that. Then, see, if you want to satisfy everything in the world and follow the code also, then code cannot be followed. Okay. You have to either come this side or that side. If somebody falls within the jurisdiction of the code, then they have to go by the code, and the code gives a power of non-abstante class that notwithstanding anything to any other law, then naturally they have to follow. We can't say give credence or we should not feel pity on other laws. Oh, at least the other law says like this, what to do. No, there's no question of feeling pity on other laws. The code has to be followed in true letter and spirit, in supersession of other laws. Okay, and these are the orders which can be passed by AA. I think in very detailed way. You can leisurely go through this. But very importantly, if you see here, if you see the point, direct for providing security charge for discharge of financial debt, which you have seen previously. In priority, and such security charge to have same priority as security release discharge. So it should not be more than what got released.
Yeah.
Exactly. That's the idea of preference. You have to avoid preference. Nothing should be given preference more than what it deserves already. So that's the conclusion here. And provided that an order in the section shall not affect any interest in the property which was acquired from a person other than corporate debtor or interest derived was acquired in good faith for value. Because there's we have to give some exception. No, some genuine people may be there, right? So require a person who receive a benefit from a professional traffic in good faith or for value of sum to the liquidator or the. So here, these exceptions here given for the person who was literally the contact, of the person that he was dealing with the liquidator or RP or the transaction in good faith. You should not get affected by this entire provisions. For the purpose of this section, it is clarified that a person who has acquired interest in the property from another person other than corporate debtor or who have received a benefit from preference or such other person whom corporate debtor gave the preference had sufficient information of the initiation or commencement or the later party shall be presumed the interest was acquired otherwise than in good faith. So there also they give an exception, and in that exception also they gave an exception. So everywhere they ensure that there should not be intention to, cheat. The intention should not be bad or to see that undue benefit is, gained. So idea is that one. So here the important thing here, the Honorable Enclave held in this matter that as it is not in dispute that the promoter of CD holds 99% and 50% in Trimla and the rest of the 50% in Trimla Balaji Alai is within the relative of the promoter, where the view that all the transactions made during a period of 2 years preceding the insolvency commencement date comes within the meaning of profession. That's all. So he completely made categorically that whatever is done, you leave at all this percentage, it is done with the intention to defraud. Means to gain undue advantage under section 33, because all this transaction is done to benefit, to gain. That's what the language here I showed you also. To benefit and gain. Do not happen, they are gaining out of it. So you see the very initial language itself that, see, the initial language itself, the transaction in a manner and, footing, effect of footing, creditor, surety, beneficial position. This word is very important. In many judgments, this word has been observed. Should not put beneficial. The entire 43, the more that the court see is that whether that particular transaction put beneficial position than any other person, other creditor. That is the main, many of the matter, it has been seen whether it is giving an advantageous position, beneficial position than other creditor. That means you are breaking waterfall of the section 53. That means it comes within the purview of 43. So this was the observation of the court in many of the cases. Even in this matters also, same the case where the AA also held that the change in the business model was beyond the look back period, could not be challenged. In this, totally things are little differently it is dealt with here. Their earlier matter was different and this is totally different. It's a very detailed case, which in fact we can deliberate in detail also. That much input is there, but left out with very less time. Okay, now going to the undervalued. Undervalued, the alternative is underestimated, underrated, and these are the meaning that we can see. We can try to understand what is undervalued. What is undervalued? How to determine undervalued? Section 45. Avoidance of undervalued transaction. If liquidator or RP on examination of transaction of CD determines that certain transactions were made during relevant period which were undervalued, he shall immediately make an application to AA to declare such transaction is void and reverse the effect. It's very important. Reverse the effect. A transaction shall be considered undervalued where the CD makes a gift to a person. Here, not creditor, to any person. So here, there in 43, it's more of creditors and advantageous position than another creditor. Okay. Here, even gives to a third person, then also it can be brought under the undervalued transaction. Enters into a transaction with a person which involves transfer of one or more assets by the combinator for the consideration, the value which is significantly less than the value of the consideration. Then also it comes under the undervalued transaction. Now 1 or 2 years, but again, if you see the same look back period, 1 year or 2 years, and the AA may require independent expert to assess the evidence relating to the value of the transaction. The power is given to the AA to appoint a person, independent expert for the purpose. Now, coming to section 47, application by creditor in case of undervalued. Here, the undervalued creditor himself can make an application if they have a knowledge about undervalued. Where undervalued is taken place, the liquidator RP has not reported to AA. The creditor himself can make an application. This is the exclusive power given to the creditor under 47 when RP or liquidator fails to report the undervalued transaction to AA. The creditor in themselves can make an application to AA to declare such a transaction void or reverse. So this is another important arm given in the hands of the creditor where they can, whereby the order can be passed, okay, to restoring the position as it existed before such a transaction, reversing the effect thereof, and recommend the board to initiate disciplinary procedure against the liquidator RP who was not taken appropriate action. So very important thing on the undervalued transaction here, because it's involved third person also. The transaction could be the third person. So that is very important. So they given even a liberty to the creditor to make an application and make sure that the transaction is restored. Very important power given to the creditor. Now in this case, the order of AA under section 45 may provide require property transferred as part of to be vested with the corporator, release or discharge any security interest granted by the CD, require any person to pay such sum in respect of benefits received by such person to liquidator or RP, and require payment of such consideration for transaction will be determined by individual expert. Now coming to comparison between 45 versus 49, transaction defrauding creditors, where CD has entered into undervalued transaction and the AA is satisfied that such transaction is deliberately entered into by such corporator for keeping the assets of CD beyond reach of any person who is entitled to make a claim against the corporator, or in order to adversely affect the interest of such a person. Here it is not advantageous, just like 43. 43 is giving a beneficial position, advantageous position. Here, if you see here 49, it says that in order to adversely affect the interest of such a person related to the claim, the AA shall make an order restoring the position as it existed before such transaction, protecting the interest of the person who are victim of the transaction. This is the difference between 45 to 49. Provided an order in this section shall not affect any interest in the property which was acquired from person other than corporator which was acquired in good faith. Same thing which you have seen it. Now this is the subtle difference between 45 to 49. Both pertain to the avoidance of undervalue transaction. Presence of any motive is not required for 45. Whereas in 49 deals with transaction undertaken with the malified and wrongful intent. And same way, look back period has been provided for the underlying transaction 46. Here, no limitation period for fraudulent transaction covered under 49 dealt with the 66 of the code. Here, 45 underlying transaction, a matter of fact, no intention is mattered. Here, the intent, once fraud, always in fraud. So that intent is important under section 49. Coming to extortionate. What is the meaning of extortionate? Exorbitant, usurious, unreasonable. All this meaning can be given to this. It's all general meaning. A transaction shall be considered extortionate under 52, where the term requires CD to make exorbitant payment in respect of credit provider. Suppose the CD took a loan, availed a loan from group company for interest rate of 40%. This has happened. I encountered this issue. Okay. So they may take. They will say that what is that commercial interest rate? Then we say exorbitant charge. That comes under exorbitant credit transaction. You can't take 40% interest rate, 38% interest rate. Okay. So then where the terms are unconscionable under principle of law relating to the contracts, then also it becomes extortionate. Now coming to extortionate credit transaction. The CD as a party to the extortionate credit transaction involving receipt of financial and operation debt within a period of 2 years, the liquidator RP make an application for avoidance. Here, make an application for avoidance of transaction if the terms of certain occurred, exorbitant payment to be made by CD. So here, importantly, here explanation they even clarify that any debt extended by any person providing financial services which is in compliance with any law in relation to the debt in no even be considered as exorbitant. As long as it is in compliance with the law, we have to show the provision that it is in compliance with the law. Now coming to section 51, orders of AA in respect of extortionate transaction. So what kind of order can person? The AA by an order can restore the position as existed before, set aside whole of part of the debt, modify the terms of transaction, and require any person who is or the party for transaction to repay it, require any interest, security interest created as part of the transaction to be relinquished in favor of the liquidator or RP. Okay. Coming to enough, we deliberated section 66. So quickly I'll move on with this. If during the CRPR declaration process, as I was telling, fraudulent purpose, AA and making application, pass an order, any person who are knowingly party to carrying on the business in such manner shall be liable to. Here, any person liable to, one, 2, if you see, it is director, which I showed you also in the earlier deliberation. Here it says director or partner. There in one subsection, any person, fraudulent, here wrongful. Okay. Now, these are the indicative list of transaction documents which may be reviewed. To see that whether avoidance transaction, what kind of avoidance transaction, all that, what are the parameters that we can see, or that what are the points that we have to look into to see that whether avoidance transaction would have taken place or not. Transaction with related party, large transaction with unrelated party, bigger transactions, salary benefits to KMP. In fact, instead of taking loan, they will take salary itself as for few crores. Okay, so we have to see whether salary in the name of perquisites, benefits, are they taking more, lot of amount from the company in the name of salary and other entitlement, movement of cash, transaction group company, sale of assets, investment made by company, inventory, all that we have to see, and transaction routed, how the related party. These are the points that we can really see, and these are the again indicative list. The purchases, sales made, and large amount of write-off. These are the general points which I listed out. Not there in the code. These are general points which can trigger in our mind that whether that some transaction would have taken place in the books and the corporate data. By seeing the books, we can really doubt whether the transaction would have been normal or avoidance. Okay, large amount of write-off and non-existent party from whom money to be recovered. There is no party at all. And transaction non-transfer property and major liability. All this can be taken as a point. How this can be verified? It may be reviewed by seeing the bank statement and publicly available document and sending letters to the debtors and verifying any order passed by any department, physical verification of assets, fixed assets, and tracing the inventories, cash by seeing cash transactions. If a lot of cash transactions are there, then also we can doubt why so much cash transactions are involved. Same way, unregistered dealer. Why the purchase has to be made from unregistered dealer? Why not from registered dealer? So, what is the claim, the time gap between the claim when we got reconciliation? Doing all that, we can see that. So, now I just thought I can put these points to you. And what is the scope of forensic and transaction audit? Okay, I have been discussed this 43, 40. 45, 46, 47, 49, and 66. Now, the question before us, what is the scope of forensic and transaction audit? Who has authority to appoint forensic audit, whether RP or COC? Whether draft forensic audit report needs to be shared with the director or corporate. On what basis RP can form his opinion that there is a profit transaction? Should forensic audit report be annexed to the application to be filed by RP before AA, whether all the entities who have been named as party in this transaction may be a respondent. These are the questions before us. We can deliberate or we can presume our own answers and move forward. Okay.
Hello.
Yeah, tell me. Yeah, tell me. Yeah, I'm getting your voice. Any doubt?
Hello.
Yeah, I'm getting your voice. Tell me.
काय तुम्हाला बघायची प्रॉपर्टी काय मिळतील ना?
So the scope of forensic audit is to find out any transaction, differential, undervalue, for fraudulent and extortionate credit transaction. All the transactions has to be scrutinized, sir, whether any of these transactions happened or not. That has to be investigated.
Okay.
Then for appointment of a forensic auditor, RP has the authority, sir. But however, the expenditure is to be taken care by the COC. So even their approval is actually should be taken, because if they are not going to pay the fees of forensic auditor, then who is going to incur that expenditure? So that based on that only we can answer this second question, sir.
Okay.
RP is duty bound to come to a conclusion whether or not such of transaction is happened or not. For that, RP has to appoint forensic auditor. The decision can be taken, but however, who is going to pay the fees of the forensic auditor?
Okay.
That is the main thing, sir.
Forms part of CARP cost. If it is
It is
approved by
CRP
COC.
cost, obviously COC has to pay.
Obviously, it
If
has
they
to.
are not
It is.
interested. In my case, as I said, as soon as I said I am going to appoint forensic auditor, they have proposed for change of liquidator.
No. So they changed or not?
Resolution has been passed, sir. They have to file an application and get appropriate order from the NCLT.
Okay, so what you are trying to say, so liquidator should not suggest any forensic audit.
No. That can be challenged. Even if the COC goes against the liquidator, I think the liquidator can challenge.
If a liquidator does not face that application, only you have to doubt. How could things are moving smooth?
No.
Every liquidator will face that issue, okay? The only which the bankers can do is removing liquidator. Nothing else they can do, okay? If they are genuine, they will help us. If they are not genuine, they will change liquidator only. What to do? Means whatever their desire they want to implement. If liquidator is not doing, then they are seeing next option. Your law permits them to do. Is it? Okay. So moving on to next. So this is another case. I think now I'll move on to. We have left very less time. What is transaction audit, which we have deliberated on the forensic audit, transaction audit. Transaction audit is nothing but a particular transaction, that related party transaction or particular loan transaction. This can be any particular transaction can be audited, and that particular based on that transaction audit, we can move on to AA for filing an application under 43. We have to see when the which section is false, then accordingly we have to go. These are the typical process, appointing an auditor, and we have to do this process. We are taking budget, POC approval, Otherwise, what happened to the Madam Santana Lakshmi only will happen unless they give in principle concurrence. They will give a surprise to us after appointment. Okay, so COC approval for budget is important to come to kickstart the process. Then request proposal, then EOA getting expression of interest from auditors, acceptance, then undertaking, then shortlisting, then engagement letter, then doing the auditor. Okay. Now, can the auditor who is appointed, can they go beyond the time frame as 11-day time frame? Can they do beyond 2 years? They have to do. Otherwise, we don't know whether any transaction of wrongful trading or fraudulent trading, which falls under 66, which does not have a time frame at all. There is no look back period. If we travel and see the past transaction only, we can come to know whether such transaction is there, which qualifies under section 66 or not. Whether it is there or not, we can come to know whether RP or liquidator. Coming to forensic audit. Okay. Forensic audit, is it really helpful for filing an application of foreign transaction? Transaction audit is okay. Forensic audit, that level is required.
If we perceive something, then I think we need to go.
Probably volume of amount involved.
Some checks are to be done. Suppose some cash flow is to be compared with the previous cash flows, and then there is some abnormal.
Minute thing you are telling. Minute thing kind of thing, or deep.
And if there is a suspicion, there is some kind of diversion or some something.
Some
Then
deep
only-
investigation is okay, then we can go for forensic.
No.
Kind of a deep investigation, right? So these are the transactions that generally should be avoided, which we have to see, okay? That we have to watch out whether then the corporate data to which we are acting as RP or liquidator. Unauthorized creation of asset. Simply they will pay by X amount, which may not be worth of it, and they would have bought it. They would have paid and just booked in the just brought into the books of the company assets. Would have paid more than what is the worth of assets. Underwire transaction through related party, circular transaction kind of thing, and preferential transaction. Well, these kind of transactions generally we know by experience. We can easily guess this particular transaction by seeing the books, diversion and siphoning, and any transaction of defrauding creditor, whether anything is there. Then any of these transactions there in the books of the CD, then we have to next to form an opinion and determine the avoidance transaction and move on application with the AA. Yeah. These are the forensic services under IPC that can be done. What can be assessment finding the irregularities under 43 to 66. Then background check all can be done. These are the approach that can be followed for proprietary transactions, payment verification, and these are the minute thing. I'll share the PPT. You can naturally go through. These are the minute things. What are the things can be done to understand and determine, to form an opinion and determine whether there is a avoidance transaction or not. For that, you have to go into deep of transaction by transaction. Then only we can understand all this. Whether concealment of property is there, any transaction defrauding data is there, any material omission is there. So these are the parameters or the points that triggers or that gives doubt. Okay, or scope for us to.
Sir, can I ask a question, sir? Yeah, sir, actually, as I said in my assignment, the corporate debtor is functioning in a leased premises. Leasehold premises of the director. Suspended director is the owner of the property, and he has executed lease deed for a particular period, and corporate debtor building is constructed thereon. So on the leasehold premises, and within the same campus, the individual, the corporate personal guarantor of the corporate debtor is running his sole proprietorship concern. So in same campus, two entities are functioning. So what happens? Creditors, their vendors, everyone is same. Suppliers, even their debtors are same, common people. So they are having machineries also. A part of machineries belongs to sole proprietorship concern. The remaining part of machineries belong to the company. So now we are unable to segregate which belongs to the corporate debtor and which belong to the individual. So, and we found a lot of transactions in the form of journal entries. It is inter corporate transactions, related party transactions without any proper documentation. Huge lot of money has been transferred from corporate debtor to individual to corporate debtor, like that. When we asked for the explanation, they said we are not aware about these consequence. We thought it is our own company. We can do inter transactions. We are not cheating anybody else. We are only rotating the funds within ourselves. So that cannot be accepted. So therefore, we have filed a preferential fraudulent transaction petition under section 66. Section 66(1) filed. So now what happened? The individual, that is the PG, personal guarantor, has preferred an individual insolvency before the subcourt, there itself, within the local jurisdiction. As per section 60, that any petition, any individual insolvency proceeding, connected petition is pending before any forum has to be transferred to the adjudicating authority who is dealing with the corporate insolvency resolution process. Accordingly, I have to transfer that individual insolvency proceeding to this NCLT. This transfer application has to be filed, whether it should be filed with the NCLT or with the subcourt where that individual insolvency is pending, or before the High Court, which is having administrative jurisdiction between two different districts. So that's confusion question still. At this stage, we are pending. Can you help in that, sir?
Which you place, man? Tamil Nadu only.
Pardon, sir?
Tamil Nadu only, no? Tamil Nadu only. State is Tamil Nadu state only, right? Company is in the.
I don't get you, sir.
Company is in Tamil Nadu?
The company is not in Chennai. It is in Tamil Nadu only. Within the same state, but different district.
That's okay. See, your problem is that after commencement of CARP before the NCLT, the individual guarantor has moved an application before district court, correct? Insolvency.
Yes, sir. Yes, sir. It is not before district court. It is filed before subcourt.
That's okay. That's okay. Subcourt, that only I'm saying district court. When madam, when the period that he initiated individual insolvency?
Individual insolvency.
Oh God, madam disappeared. Okay. Okay, we'll move on. Let us join again. Okay. Once she joins again, I will take it forward. Okay. Now, as I was referring this, oh, these are the routine things. Okay. Oh, I've gone back. Okay. Okay. Indicative list, all that we discussed. Fine.
I'm sorry, sir. Due to network problem, call got disconnected, sir.
Yeah, tell me, madam. Yeah, tell me, madam. See, wait. Now coming to your point, see, I was asking you one point. When the individual insolvency has been initiated, how long means?
It was initiated prior to CARP commencement, sir.
Oh. Because the provision of section 60 says that when if the CRP is pending before relevant one particular NCLT, then the individual insolvency also should come there, right? Should be filed, that should be heard by the same NCLT. But here you are telling the individual insolvency already commenced in the subcourt. After that, the CRP has got initiated, correct?
Yes, sir.
That means then you have to move to the subcourt only and say, because that's the preceding matter. Okay, that precedes.
So we have to file an application before the subcourt.
Yes, we have to say that this matter has to be dealt with by NCLT. Earlier, when it was filed, there was no CRP pending before NCLT. Today, quoting the provision, you have to say, today they are not legally permitted to present the matter before you, after the matter, pending before the adjudicating authority. So we have to convince the subcourt judge and tell them that subcourt judge has to pass an order that you can go before the same, because otherwise it can't be decided. The idea is that the company and the PG, okay, if same NCLT adjudicating authority hear the matter only, they can decide the matter and in one shot. Okay. There
yes, sir.
Yeah, otherwise, subcourt judge may not know anything about corporate data. Same way NCLT, they may not know about individual guarantor, what their liability and what are the assets. There are many complications are involved in that. So I think it is good for subcourt to transfer. Okay. So better to engaging a counsel, you have to approach subcourt. Because that individual insolvency only commenced first, initiated first. After that only CRP is initiated. Okay. It would be proper to approach subcourt first, to asking the subcourt to pass an order. Not passing order, closing the matter, asking him to go before the NCLT. Okay. You understand my point?
Yes, sir. Yes, sir.
You have to pray, you have to ask, seek a direction from subcourt to close the matter in subcourt, give a direction to the party to approach the NCLT where the CRP is pending for remedy. Okay?
Okay. Okay, sir. Sure, sir. Thank you, sir.
There's another last concept which we want to touch up. I want to just touch upon before closing. Last asset tracing. How the asset which is lost could be traced. Because many of the company which we are acting as, CD, which many acting as a RP or liquidator, and few companies would have encountered also, would have come across also, the assets and machineries may be missing, or they would have been taken away by the management, or on instruction of management by somebody. So all this has to be done with the excess of asset tracing, last asset tracing only. I think with that forensic audit only can help how the last assets could be brought in, or at least to get the detail. Then we can go for we can approach the adjudicating authority, get the order to restore. But for that, we need to engage a proper, appropriate professionals or agency to see that the last asset is traced. Then move an appropriate application under avoidance transaction, so that the last asset could be brought back to the CD. So these are the, some phases that we can understand: pre-investigation phase and the investigation phase, judicial phase, and the dispose. This is how every matter has to come. This only I was telling 66 fraudulent trading, and it is subsection 1 is about fraudulent trading. Any person who are knowingly party, it can be maybe made liable to make such contribution, whereas in 62 only the director or partner only can be, the relief can be sought only against the director. Same way here, if you see punishment or concealment of property, which are showing that I will be handbook where it was saying the punishment. Same thing only, section 68. If fraudulently removed any part of the machinery, whatever the application filed under 66, okay, can be combined with this section 68 for removing of plant and machinery, so that we can file an application for contributing to the asset for the last machinery, whatever the goods that has been taken away from the premises. Same way, concealment of property. All this is a criminal thing, which I explained in my earlier slide. So if any doubt, we can discuss. I thought I can take, anyway, I covered case laws while deliberation itself, because I thought separately I can cover, then I covered then and there. I covered the case law so that it would have been easier.
So I need your advice on this post passing the order of the NCLT, how to get it executed and how the liquidators or RP should deal with that, considering the time and cost involved. So,
to put it other way, you are asking that how the avoidance transaction in liquidation could be handled, or is it?
Once if the order is passed for say restoring the assets or bringing the money back to the company,
okay,
so it is the onus on the RP or liquidator to execute that.
Correct.
So now,
liquidator who has to make sure that the order is executed and money is recovered from the promoter or wrongdoers, then that has to be distributed as per the waterfall. That only
no, but if the situation comes that dissolution happens before this buffet applications are disposed of, so in that case, how the liquidator should take care of this time and cost involved?
I feel that dissolution will not um, give a liberty to the liquidator to skip responsibility. Because when the dissolution was ordered, the avoidance transaction was pending only, right?
Right.
That application was pending only, right?
Yeah.
That means the court, while passing the order, while passing the dissolution order, should have dealt with the avoidance transaction case which is before them. What is the fate of it? Then only they should have passed the dissolution. Otherwise,
so there is a regulation 44A that is exactly incorporated for this purpose only.
yeah,
To
correct.
take care of the situation when the dissolution happens before the.
Correct. Recently they also, yes. Correct. If that's the situation, wait, I'll show you that. What you are telling, regulation. That got introduced, no.
Yeah, so that says that SCC, liquidator in consultation with SCC should decide how to deal with this situation.
Yeah.
While filing the resolution application.
That means before closure, right?
Before closure, right?
Yeah. That is there. But if you see, just a moment. What is the subclass you are telling?
44A.
Oh, yeah, I'm seeing the regulation.
In the regulation on the liquidation process regulation.
Yeah, that's what I'm seeing. Wait. No, I want to show to others. See, detection of fraud. Final report only you are telling, right?
No, it's I think a separate provision. 44A, I think they have, or 24A.
44A, na?
Yeah.
Treatment of avoidance transaction.
Yeah, I seen it also. I wanted to even cover that portion also. Wait. 44A you are telling. I seen somewhere else. Wait.
Shall I read, sir?
Yeah, please read.
Treatment of avoidance transaction. The liquidator shall, on the advice of consultation committee, provide in the application along with the final report filed under regulation 45 for the manner in which proceedings in respect of avoidance transactions, if any, under chapter 3 are fraudulent or wrongful trading under chapter 6 of part 2 of the code will be pursued after the dissolution or closure of liquidation process, and the manner in which the proceeds, if any, from such proceedings shall be distributed.
So it implies that the liquidator will be discharged and the fellow who will be taking over this responsibility, he will be dealing with that UPA application.
What you are telling is 44A only, right?
Yeah.
Wait. Liquidation regulation 44A. I think what I'm keeping here, I'm not allowing it.
Maybe the old edition. This is a new introduction.
No, that's what I'm saying. Yeah, I've seen this provision. I've seen this also. I wanted to cover that also because very important thing on this particular aspects. Yeah. Yes. That's right. Yeah. It's only right. Now I was keeping the earlier one, I think, not updated one. But how could it not got updated there? Yeah, regulation 44, the liquidator shall on the advice of consultation committee provide in the application along with final report. See, okay, correct. Here only I wanted to tell something. If there is a consultation committee, you can take advice. If there is no consultation committee, then you can't take advice. Then what is the position of liquidator then? So liquidator on his own, he has to decide. Correct. The liquidator shall provide in the application along with final report. Regulation 5, the manner in which proceeding. Anyway, you have to we have to answer. No.
Committee is also not very clear what to do with this.
This only I was trying to convey to you. End of the day, as a liquidator, we are even here also they are telling, give an obligation only to the liquidator only to say how he will be dealing with that, right? There is no solution given.
One suggestion I have put before the SCC was that the secured
What
creditor
is
who will be
SCC?
getting the maximum benefit of this.
Assuming SCC says, we don't know, you deal with that, what you will do?
So
Assuming
if the committee doesn't agree to what suggestion liquidator is giving, so then on his own liquidator can tell the court that, okay, the secured creditor who is having the maximum stake in this whole process, they will take the responsibility.
What you are saying is a problem of everyone. What you are saying is real problem of everyone. Yeah. Because see, every liquidator has to face this. Okay. Every liquidator has to face this. No doubt, every liquidator has to face this. Yes. I think just a moment in IBBA.
Because it involves time, cost, everything. If the proceedings continue for years together.
Here also 44A, while they introduced also, they didn't give solution. They are only asking liquidator to see that filing the application, provide the provision. What kind of provision you will provide? What kind of provision we can provide then? We have to handle only, no?
No, just like in resolution plan, we hand over the pattern to somebody else, maybe the secured creditor. In the resolution plan, the transactions can be handed over to the either the resolution applicant or to the secured creditors.
No.
And they will be taking care of that after the approval of resolution plan.
If it is a resolution plan stage, plan can provide for and it goes after plan. Okay.
So it is similar line. Similar line, they want to have a solution in this liquidation process also. That's what I feel.
See, the difference, see, please understand the difference. In resolution plan, you are leaving the decision to the COC. Okay. Because the resolution plan already carries the provision how the avoidance transaction should be dealt with on approval of resolution plan. It is already inbuilt in the plan itself. And it is getting approved by COC and getting approved by adjudicating authority. Correct?
Yeah.
So that means the blessing of COC and adjudicating authority is there for the resolution plan. Here, because there, with that agreement only, the plan getting approved. But here, the application which is liquidator is moving before the adjudicating authority, liquidator has to provide. What to provide? That only I am asking. As a liquidator, what you will provide?
Even in
No, the
CARP
practical
also,
solution is that the creditor who is getting maximum benefit out of this order from adjudicating authority.
No creditor will take
the responsibility.
Sir, please understand, no creditor will take this. Because if the creditor is company, individual, at least they will consider. If it is a bank, means they will not take that responsibility. Because they have a lot of their own protocols and their own decision. I told you, no, as it is decision making itself, they are not taking quickly. And this
is what is happening.
So this level, I don't think they will take a chance that to leaving liquidator free. They will not do. We have to see that before dissolution, it has taken to the knowledge or the relief is sought before the adjudicating authority. As you said, whether creditor is taking it or some other remedy before the adjudicating authority, then if the adjudicating authority provide in the order, then liquidator may be relieved. If nothing is there, then liquidator has to travel with this. Problem is that only.
The creditors will pursue, sir. If they want to pursue it further, if they want to pursue it further, they have to appoint the liquidator. They have to ask the liquidator to continue it. And he has to be paid.
No, you are not understanding. Please understand the question. Yes, here the question raised is after dissolution. After dissolution, avoidance transaction matter case is pending before adjudicating authority. First, who will handle it? Who will represent it then?
So that is what they say in consultation with SCC, liquidator should decide how to handle this.
Correct. No, SCC says, no, we are not worried about it, you decide. Assuming I'm a,
SEC, they are the controller of the unit.
they are not here to give solution to liquidators, because the law says decision of SEC is not binding on the liquidator. The law says decision of SEC is not binding on the liquidator. Then SEC says that anyway it is only a suggestive only what I am telling. You decide. They will simply leave the matter decision to the liquidator only. Because at least like just like a COC where we have to listen means okay. Here after SEC says also, still liquidator can have a different view.
It is ultimately for AA to decide whether to accept the SEC's view or liquidator's view in this.
Exactly, that only I said. We have to take it before AA only, and we have to make sure, ensure that AA is giving some order. AA gives some relief in the order.
Or in the final report itself, the liquidator can mention what is to be, how to proceed, and the AA will take a.
No, that's right.
He cannot. Liquidator himself can say that the creditors have to pursue the avoidance transactions further.
Exactly. That way we have to seek a direction.
Then they should cover the cost and compensate the liquidator.
Yeah, if the credit, if the SEC wants the liquidator to pursue, then again there must be an agreement for paying the liquidator costs.
See, while moving application, the liquidator has to seek a relief from AA that since the dissolution is after dissolution or closure of liquidation, liquidator will not have a legal, what to say, authority to represent as liquidator, right? After
this, one thing is that suppose if the proceeds of the avoidance transactions are realized, who will be the beneficiary? Not the liquidator.
Creditors only. Yes.
Creditors. Then it is their duty to proceed. Suppose if they are not interested and they don't want to pursue it, we will, if it is realized, then we will make it accountable to the IBBA.
In which case, what could be a suggestive thing? Moving application with the AA, making all SEC members as a party.
Yes, COC has to do that.
Get an order from AA. That is the only way. So AA has to decide.
Some proposal has to go to AA. Na? So AA will say, okay, what is the proposal?
Other way, no. See, there's no other way. Who are the beneficiary? Those beneficiaries should be made as a party in the application. That way only liquidator can come out. Otherwise, liquidator cannot come out.
There.
Well, what to do? I told you, no, there are many questions which is there in our mind, we don't have answers. Even after dissolution, the matters, somebody files a case, what is the position of liquidator after dissolution? You tell me, no? After dissolution.
That order also may be challenged, yeah. So what liquidator can?
What?
Dissolution order may also be challenged by someone, and then you have to face them.
After dissolution also, even see, we don't know what kind of a case matters will be filed against the corporate data, we don't know. After that, who will send the case? Otherwise, what happened? No, the dissolution application or closure application cannot be done till all cases are getting concluded.
Yeah.
That is the only way. Keeping it live. Only thing is the liquidator will earn a bad name that he is not completing a liquidation process. The liquidator has to say there are pending litigation. You please close that also, close the liquidation also.
Yeah.
Yeah, what to do? We have to balance only.
Sir, in one of my past assignment, dissolution happened 2 years ago. Last week, I received one letter from TANGETCO asking for the details of the bank account to transfer the deposit amount. Then I replied to them, IBBI, what is that? undistributed funds that has to be transferred to liquidation account of IBBI. Those details I have shared and asked them, whatever may be the payable, kindly transfer to that account and file annexure 1, form 1. I just replied, I am no longer liquidator and company is also not existing. It is dissolved long back.
Yeah, what to do? That is the only way out. As a liquidator, you cannot get the money. There is no liquidation account at all. No, you would have closed the liquidation account before filing a dissolution. Right?
Liquidation account already closed and the company is dissolved.
That
And
only
the
I'm saying.
MCA record also
see,
updated.
madam, I just a minute. There is a form J, na, which is to be submitted by the stakeholder to the IBBA for withdrawal of such funds.
Yeah, there is a form J. Is wait, I'll show you that.
Withdrawal from corporate liquidation account. Form J is there.
That only the beneficiary, whoever is entitled, can withdraw.
Yeah, that signature of the stakeholder, that form will be signed by the stakeholder himself and submitted to the IBBI. And I think there is some executive director will take a call on that.
By J, na?
Yeah.
Yeah, that has been introduced actually. Right. Oh, this I think another. This is old form of this thing. Okay.
The old one, I think, yeah.
Yeah, old one. This also I closed. Lot of things are kept up. That's why reason. Yeah, this one. Form J.
Because in the form I, when it is deposited with IBBI, the liquidator has to furnish the names of the stakeholders also. Very recent addition is that. Liquidator, he deposits the entire amounts of unclaimed dividends or unclaimed proceeds. Then they will submit form I at the end of the liquidation. In that, they have included one, there is already one B, para B, and this B is also now changed. They have changed it and they have to give the names of the stakeholders and their claims which are pending as on the date of closure of liquidation.
Form IJ. Form J. You are telling in the regulation form J.
Form I and form J are there, sir.
No,
Form
no.
I, liquidator has to submit along with the
Form I.
proceeds.
Yeah, I got it. Yes. Yes. So this is the form you are saying.
Yeah. At the time of deposit of the term. And form J is at the time of withdrawal by the stakeholder.
Yeah, correct. This is when the provision has been introduced, they introduce this form also. See?
Yeah. And this para B is there, no, sir, in the I. It has undergone a change. There are only, earlier there were only 7 columns. Now there are 10 columns.
Yeah, correct. No, they introduced one to, I think in 29 January recently, they introduced one change.
Yeah.
Also.
Earlier it was only with 7 columns.
And
Form J is to be given by the liquidator to the IBBI for withdrawal of his claim. He has to submit along with the proper proof.
I think this format has to be followed. I think this particularly they introduced this for this purpose only they introduced this.
Yeah.
Anyway, madam, you written letter to them. See? You can just go through form I and J, madam.
Yes, sir. Thank you, sir.
See? Declaration and all they are asking. Okay. My God. Hmm. I undertake to refund entire interest. Okay. Good. Hmm.
Are all books and to be maintained. I
Yes,
don't
yes.
know whether the people are maintaining these books.
Ah. We have to supposed to maintain. Okay. Fine. Any other doubts?
Sir, in case of CIRP also, suppose even if it is mentioned in the information memorandum and in the expression of intent everywhere, suppose the successful resolution applicant is not in favor of taking up the, what is this avoidance transaction litigations forward. It is,
He has to.
it will also be pending.
No, no, no. You have to make a provision in the resolution plan that he has to take it forward. Because after once a resolution plan is approved, the provision says that the RP is discharged. Correct? No, once the resolution plan is approved, the provision is very clear that the RP is discharged, he is supposed to hand over the papers. Then after that, how he can proceed avoidance alone? We cannot proceed avoidance because the new management only should take care of it. They have to agree, I am saying. And what I am saying in plan, they don't have option at all. Only liquidation stage, there is no clarity. I think liquidator is still answerable. Otherwise, he has to see that everything is getting over, then file a dissolution. That is the only way. Any doubts?
Then till this, if applications are disposed of, liquidation will be held up. No dissolution can happen.
What to do? That problem is that only. In fact, first of all, the cases which is already pending before AA or appeal or whatever it is, first all that get concluded. No. After distribution also, there is no assurance, no case will be filed against liquidator. After distribution. After distribution.
Yeah, after dissolution, he is discharged from his responsibilities after dissolution.
No, that is okay. See, after passing dissolution, you are discharged only. That is, AA should have taken, or you should have appraised the AA before dissolution itself. After dissolution, the AA has to see that what is the remedy for it. Because the liquidator is out after dissolution. Your order should have provided, no? If you have got dissolution order, the order releases liquidator or not?
No, it has not gone to that stage. It is with the SCC only right now.
Then what is that?
SCC has not taken any decision. Yeah.
Okay, then SCC only you have to see, or then only you have to. Good. Madam, any no question, we can conclude, madam.
My doubt is when the avoidance transaction, when it is not valued, how will the resolution applicant takes it forward? See, unless we know what is the value involved in the avoidance transaction.
No. See, when you are filing an application.
We are filed, sir. That is pending with a.
That's what I'm saying. Without knowing the value, you file the avoidance transaction application?
No, still it is to be adjudicated, no?
No, that is over. That he will take it. See, if he gets money, who will take? If he gets money.
No. Suppose if that avoidance transaction is adjudged, that these assets are to be brought back to the corporate. Say, for example, the corporate data. Who will be the beneficiary there?
That's why I'm saying here, either the resolution plan should provide that the after order is passed, okay, in avoidance transaction, if the money goes to the creditor, whether the money will go to the creditor or whether the money will go to the resolution applicant, the plan itself should provide for it. If money should go to the creditor, then naturally when the order comes, it goes to the creditor. If money should go to the resolution applicant, then it has to go to, because Agreeing that only COC is approving the
Sup-
plan.
Suppose if the money has to go to the creditor,
Hmm.
then who will pursue?
Who?
Who will pursue that further?
Once plan is approved, then there is no question.
And then when SRA is not going to be benefited out of the avoidable transactions and he wants to
You have to
handle-
ask the court only while approving the resolution plan. You have to ask that in the court. What to do? Because here, whatever we decide also, nobody is going to accept it. Okay? Unless it is supported by court order. Even any interpretation we give.
somewhere I have read that the IP has to continue the proceedings even after that CRP is finalized.
No, that is only in the order. One of the order I only told that. I only
also read
told
that.
one of the judgment it is like that, not in the IBC. In one of the judgment Venus Enterprises, I told Supreme Court said, no, RP has to continue. That is the judgment of the Supreme Court. The not yet been brought in code.
So then, as good as in liquidation, it is there in CRP also.
No answer. No answer. Only we have to encounter. Okay. Okay. Good, madam. We can close the session, madam.
Thank you very much, sir, for giving your valuable time and sharing your knowledge and experience with the participants. And I think time.
आज कौन आदमी वैसे खरीद रहा है, सब ऑनलाइन खरीदते हैं।
2-3 people are giving voter thanks.
सब्जी ये वो
Okay, madam. We'll close. Thank you all
The
for your patience.
session was very lively, sir. Thank you. Thanks a
Thank
lot.
you, Dhanapal. That was
Thank
a
you.
nice presentation.
Okay. Good after a long time.